Honorable Court of Criminal Appeals is now in session.
Thank you. This is the first day of the Court of Criminal Appeals March term in West Tennessee. On the panel today, to my right, Judge Tim Easter from Williamson County. To my left, Judge Ross Dyer from Shelby County. I am Kerwood Witt. I'm from Monroe County. Call our case, please.
Curtis Keller versus State of Tennessee.
Arguments are 20 minutes aside. If the appellant wishes to reserve a portion of that time, then you need to make an announcement at the beginning of a reservation of time for rebuttal. And you may proceed.
Thank you, Your Honor. May it please the court, Lance Chisholm from Shelby County. I represent the petitioner, Curtis Keller, in this post-conviction appeal. At this time, I would respectfully request 2 minutes for rebuttal. I raise a number of issues in my brief in this case, but today I'm going to focus on the issues pertaining to the DNA, whether or not counsel should have hired his own independent DNA expert, and whether he should have interviewed Dr. Quadria Debnam, who was the DNA expert who testified for the state. So those are the two issues I'm really going to focus on. Again, hiring his own expert and cross-examining and interviewing the state's expert. A brief summary of the case is, I think, in order to understand these issues. This is a case where Mr. Keller was alleged, the state's theory of the case was he was the mastermind of this home invasion that occurred in Germantown in 2008. Mr. Keller apparently came up with the idea and gave everybody supplies or helped to supply all of the participants. So all of the participants, which were his co-defendants, got in a van, a white van, and went out to Germantown, broke into the house, committed the home invasion. Mr. Keller was not in the white van with all of those participants. He was driving around in his blue Dodge Ram. There was proof that that's the kind of vehicle he drove, a blue Dodge Ram. And so basically, the main proof against Mr. Keller were his two co-defendants, Jeremy Munson and Curtis Hayes. They testified everything I just said. He set it all up. Mr. Keller set it up and was a mastermind and kind of acting as a lookout in his blue Dodge Ram as the crime was occurring. So the issue becomes, was there some adequate independent corroboration of these co-defendants' testimony? Because in Tennessee, we have to have something corroborating not only that a crime occurred, but that the defendant was implicated, showing his identity in the crime. And what this court held in its decision on direct appeal was that the fact that Mr. Keller's DNA was on a ski mask recovered from that white van, that supplied the adequate independent corroboration. So Mr. Keller's DNA being on that ski mask was critical to the state's case, I would submit. Now, there also was some proof that on the dash cam, for a split second, when the officers are chasing the white van, you see they're in the left lane and they're coming up behind a blue pickup, and that pickup moves to the right lane and the officers drive past it real fast. So I will concede for a split second, you can see the taillights of looks to be a blue pickup. And even though I think it's important to note this court on direct appeal never really referred to that fact as being part of the corroboration. In fact, nowhere in this court's decision on direct appeal do they even mention that dash cam video with the blue truck. But the state in the lower court and in this court is arguing that that was the independent corroboration as well as the DNA. So, even if I don't win on this DNA issue, their position is, well, you had the blue truck. But I would respectfully submit that just a brief glimpse of a blue pickup truck is not enough independent corroboration to implicate Mr. Keller in this crime. So we're back to what is the adequate corroboration, the DNA. And the question becomes, should counsel have hired his own expert to determine whether or not Mr. Keller's DNA was in fact on that mask? When I asked counsel about this at the hearing, post-conviction hearing, he basically said he gave about 3 or 4 reasons why he did not do it. And I would respectfully submit that these are not reasonable reasons. These are not adequate reasons for not getting your own expert. And before I get into those, I will just state the law on this is set forth in Kendrick versus State, Tennessee Supreme Court, 2015. It says that in most cases, the decision whether to hire an expert is a strategic decision that we're going to kind of defer to. That being said, the Kendrick court said each case must stand on its own facts. So you really do have to look at the unique situation in each case to determine whether or not counsel should have gotten an expert. So in this case, I would submit it was not reasonable to forego an expert. Counsel said his first reason for not getting the expert was that he had used Special Agent Lawrence James in a prior case. James was the state's witness against him in a prior case, and Special Agent James was very open with counsel about the facts in that case and gave counsel some information that exonerated his client. So trial counsel in this case said, I just had no reason to question the TBI since Special Agent James was so helpful and forthcoming in the prior case. 2 things about that. One is simply because Agent James was helpful in a prior case doesn't guarantee he's going to be, as helpful as in this case. So that's not a reason in and of itself not to challenge the DNA, I would submit. But more importantly, Special Agent James was not the individual who took the DNA profile off of the ski mask in this case. That was Dr. Quadria Debnam. So that's where a problem could have occurred in her lifting of the DNA off the mask. So all Special Agent James did in this case was he got a sample from petitioner and compared that to the DNA that Dr. Debnam had already collected. So Mr. James's role in this case was pretty minimal. So the fact that he helped in a prior case should not have caused counsel to, again, forego an expert in this case. Counsel also said that he believed that the DNA on the mask was not that helpful because, petitioner was not even in the vehicle. But the whole point is that's what the state used to corroborate the accomplice testimony was his mask being in that vehicle. So counsel saying that, he didn't find it that important since petitioner was never alleged to have been in the white van. It's just not a good reason not to test that mask because that's what the state used to corroborate the accomplices.
Mr. Chisholm,
Yes,
I don't mean to short circuit your argument a little bit, but I mean, you got this, you got an issue here. You didn't produce an expert. You don't have a DNA test. How do you get to prejudice?
Yes, Your Honor. That's where I was going next. This is a case where I got appointed in, late around November, December 2017 on a post-conviction. As I was working, we were in Division 4, Judge Carolyn Blackett. And so as part of working on the case, I subpoenaed the TBI file around March of 2018. Started looking through the DNA file, TBI file, and Mr. Keller looked at it too. Together we viewed it, and he found some evidence that he claims was never turned over. So he was pretty adamant that he wanted me to file a quorum nobis at that point. So I went ahead and filed that around, I think, September, October of, I would say, 2018 is when we started heavily pursuing that quorum nobis. And we put the post-conviction on the back burner. And so we litigated that quorum nobis up through about September or August of 2019 for about a year there. Excuse me. And so it was finally denied. And then this court actually about a month ago upheld the denial of that quorum nobis. So around the fall of 2019, we get back on this post-conviction. We're still in Division 4. And I knew that being in Division 4, that she was going to work with me on, giving me time to do what I needed to do, which was to get this mass tested. And it was about that time, in the fall of 2019, that Mr. Keller's family came up with the money and hired George Shiro, a DNA expert down in Mississippi. So around, I guess, August, September, October, what I'm doing during that time, I'm trying to get with Miss Bird, the prosecutor, and coordinate a way to get the mass down to our expert. I've personally never done that before. I've never had evidence shipped to a DNA expert like that. So I was a little, I was kind of learning as I was going too, but I was talking with Miss Burr. I was talking with the clerk's office, trying to coordinate, find the mask and everything. And so anyway, around October 30th, 2019, Judge Blackett, I went in there on a report date, and she said she's recusing herself because she ruled against us on the quorum nobis. She said she felt like she didn't want there to be an appearance of impropriety on the post, since she's already ruled against us. So she recused herself, and the case randomly got assigned to Division 3, Judge Carter. So, I go into Judge Carter's court around early November. I can't remember the exact date, but he made it pretty clear, that, hey, this case has been going on a while. We're going to have a hearing. We're going to set it January 9th, 2020. I can't recall. I think I may have mentioned, there's some things when I need to do with the testing and whatnot. And I think he was adamant, look, we got to get this heard. It's been going a long time, So, I went from a courtroom where I knew the judge was going to work with me and was going to, give us time to do this, to a courtroom where, this hearing was going to be held very quickly. So I told Mr. Keller that. He got a little upset, that the hearing was going to go so quick. This is around late November, early December. I remember he mentioned to me at one point, don't worry about it. I'm going to hire my own lawyer. Just don't worry about it. That kind of threw me off, and the holidays were coming up, and so it was just really it was unfortunate, just getting transferred to new court and the hearing set, and Keller. I don't know if I mentioned in the lower court about Keller talking about hiring his own lawyer. I don't think I did, but that was something I thought of as I prepared for this argument too, that did happen. But bottom line is, and I told this to the post-conviction court at our hearing on January 9th, it never got done. We never got that mass tested. A lot of it had to do with me kind of being first time to get it done. I had a lot of appeals, post-convictions going on in fall of 2019. I know that's, no excuse. But the mass never got tested. And so I thought, I would just ask the court for a little time on January 9th. We could have the post-conviction hearing and maybe hold it, let us do the testing. But when I brought that up, the court first of all said the testing should have already been done. Mr. Keller's had years. This post-conviction pending, it could have been done. That was one of the things the court stated.
But you raised that the day of the hearing. You didn't raise it. You didn't ask for the continuance. As I read the briefs, you didn't ask for the continuance until the day of the hearing. You didn't.
Yes,
the record will bear out what happened, but you didn't ask when you got transferred. Hey, Judge, we've got the money. The family's hired an expert. We just have to figure out how to get the mass down there. Can I have a continuance? As I understand the record or from the briefs, you asked for a continuance the day of the hearing. I mean, I can see the trial court's frustration and why he denied it. You did have from August, when the family hired the expert, until January to get that mass tested.
Right. I mean, that's correct, Your Honor. I mean, I can't really, there's not a whole lot I can say, to justify that, except for what I've said. I'm just trying to say it wasn't like I was just trying to blow this off. I mean, I was really making efforts to do it. But, when you're handling a lot of cases and you're trying to talk back and forth, coordinating efforts to get the mass tested, it's just kind of, I ran out of time on it. But, I think this is such a critical thing that Mr. Keller should be given that opportunity to get that mass tested. I mean, it's rare that a family comes up with money to test a mass. And so he's got the money. The post-conviction court really on January 9th was, I mean, he mentioned about how Keller had time to do it, but he also mentioned that he just doesn't feel the mask is really that critical in this case. You know, a lot of his analysis was like, you know, even if it showed his DNA is not on the mask, that wouldn't matter. And I just respectfully disagree with that. I think it would make a huge difference if our experts show there was no DNA on that mask, Keller's DNA. So, you know, I think the court, I can see what Your Honor is saying about it could have been done, but I think just considering the totality of the circumstances, how we had the case on hold for a while we were pursuing the quorum nobis, and then we, you know, got switched to a different courtroom that immediately set up for a hearing, that, you know, Mr. Keller should be cut a little bit of slack in this situation because the DNA is so critical. And I would just hate to see him not have a chance to have that tested for, you know, anything I may have done. You know, if I was.
Let me ask you one more question, and I'll let you proceed. But why can't you go under the PC DNA Act and get it tested?
Well, I thought about that, but I think the problem there is that act requires and this is my understanding, if I'm wrong, correct me, but you have to show one of the prongs is that the evidence has not been subject to DNA testing yet. And this mask, it was tested, you know. So I think he's out of luck there, unfortunately. And this is really his only chance to get it tested is through a PPCR, you know, saying counsel should have done it. So again, I would just ask the court basically for mercy, you know, on Mr. Keller here, to give him a chance to get it tested, considering the totality of how this all went down. Certainly looking back on it, you know, I would have done it differently if I had a chance to do it differently, but, you know, hindsight's 20/20. But so the DNA is a huge deal. Now, the other issue is the Dr. Debnam. I'm saying counsel should have interviewed her because she's the one that lifted the profile. And there are some issues about whether maybe Mr. Keller's March 2009 swab got commingled. And I go into all that in my brief, but the bottom line is I did not produce her as a witness either. However, I did a little better on this one. I did get her a subpoena issued for her. It's in the record showing they tried to serve her. She works at Whitehaven High School, and they tried to serve her January of 2020, and school was out. It was like January 3rd. And I asked the court for a little more time to get her resubpoenaed. Court said, no, you know, I don't feel, like I said, the court said, I don't feel the DNA is important here, basically. We don't need Dr. Debnam. He said, you can't even tell me, Mr. Chisholm, what she's going to say. You know, we don't just bring witnesses in, you know, just hoping that they say something helpful. But, you know, to that I would respond, in post-conviction, you're required to put the witness on to show what they would have said. She was not returning my phone calls. I was trying to talk to her throughout 2019. I made several calls to her at the Whitehaven High School, left messages. She wouldn't call me back. So, you know, I had no choice but to subpoena her to see what her testimony was going to be. So it is true. I don't know what she was going to say, but to prove prejudice in a post-conviction, I needed to put her on there. Like I said, I did issue that subpoena in a timely manner. So I would just ask the court to let us at least go back and get a chance to, you know, get her served and put her testimony on. All the other issues I think are covered adequately in the brief. You know, unless there are any questions from the court, I would just ask the court to reverse the decision of the post-conviction court. Thank you.
Thank you. Mr. Coleman.
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. The petitioner has raised a variety of claims of ineffective assistance of counsel, but he has limited his oral argument to claims surrounding the DNA evidence. So unless this court has any questions about the other claims, I too will limit my discussion to the DNA evidence. And I think first and foremost, when you're looking at whether this was ineffective assistance of counsel, you have to look at whether trial counsel's decisions were reasonable. And here, trial counsel testified exactly as to his reasons for why he chose a different avenue of investigation. And that's essentially what the petitioner's DNA claims boil down to, is that counsel should have more thoroughly investigated this DNA. But counsel explained that instead, this DNA was not crucial to his defense. That instead, there was never an allegation that the petitioner was in this white van, had actually been a perpetrator of the crime, was physically present. There was no allegations of that whatsoever. Instead, what the proof at trial was that two co-defendants testified. I think Mr. Chisholm adequately described it as the petitioner was the sort of mastermind of this case. He had planned it out. He had sort of provided the actual perpetrators with the information. And so trial counsel made a reasonable decision to say that I'm not really going to go after this DNA test. That's not the crux. What is the crux is the credibility of these two co-defendants. And again, that was a reasonable decision, especially when counsel emphasized that he had no reason to doubt the veracity of the DNA test. It wasn't just that this special agent had helped him out before, but it was that, there was no reason to doubt that the hit on the petitioner connecting him to the ski mask was anything but authentic. And so when you've got that information in front of you, and when you've got this, the fact that these two co-defendants are kind of what really tie the petitioner to the case, it was a reasonable decision by trial counsel to pursue an avenue that would allow him to effectively cross-examine them. And this court will read the original decision. The trial counsel did in fact cross-examine them somewhat effectively to minimize the petitioner's involvement and to impeach their credibility, both with their identification of the petitioner and with their overall testimony. And so I think that you're looking at the first prong of ineffective assistance of counsel is deficiency. And here, trial counsel simply was not deficient. He made a reasonable decision, and it did not fall below the objective standards of reasonableness. But even if you go to the second prong, dealing with prejudice, I think first and foremost, we have the fact that the petitioner has conceded he has not established prejudice in the case below. And I'll discuss the continuance issue shortly. But I think even if you go beyond that, even if we were to accept wholesale his claims that maybe this DNA evidence would not have attached him to the van, we still have corroborating evidence in the form of this pickup truck. At trial, and this court has the transcripts, there was testimony by the co-defendants, there was testimony by police officers, and there was dash cam footage of this blue pickup truck. And Mr. Chisholm mentioned that the petitioner had filed a petition for writ of error quorum nobis, and that this court had recently affirmed the denial of that petition. And I think it's important to note something that this court said in there. And the case citation, if your honors would like it, is West 2019 01652 CCA Rule 3 ECN. And at pages 7 to 8, this court emphasized, because the quorum nobis petition dealt tangentially to this DNA evidence. And so this court emphasized that the DNA evidence wasn't the only corroborating information. And in fact, emphasized that this pickup truck was sufficient corroboration to support or to corroborate the accomplice testimony. So I think this court has sort of already dealt with that. And that's why we can prove that not only was counsel's decision reasonable to the point where it's not deficient, but also the petitioner simply cannot establish prejudice, whether it be by conducting an independent DNA test of the ski mask, interviewing the doctor who performed the testing, or somehow more effectively cross-examining her during trial. None of that would have been prejudicial. Even if counsel should have done all of that, it wasn't prejudicial because we have this additional corroborating information. And so for that reason, the petitioner cannot establish ineffective assistance of counsel surrounding the DNA claims. Kind of connected to that, and as the petitioner concedes he can't establish prejudice, part of the reason is that the post-conviction court denied 2 requests for a continuance at the post-conviction hearing. And one was related to a request for a continuance to start the process of getting the independent DNA testing of the ski mask. And the second one was to get additional time to try and re-subpoena Dr. Dednall. And so when you're looking at the first one, and the claims regarding the continuance are reviewed for an abuse of discretion standard. And so here you're looking at, did the post-conviction court abuse its discretion in determining that continuances weren't warranted? So regarding the independent DNA testing, the post-conviction court emphasized that this case had been going on for a significant period of time. If my recollection is correct, the petition for post-conviction relief was filed in 2015, and counsel had been appointed by 2017. So this was going on for approximately 3 years at minimum before the hearing even started. And the post-conviction court commented that this had gone on long enough, that there was ample time, especially considering that the quorum nobis issue also dealt with this DNA, that there was ample time to have an independent test conducted, and that it wasn't going to grant a continuance. And I think that was a reasonable exercise of its discretion. And then again, I think when you're looking at whether it was an abuse of discretion and whether the granting would have changed the outcome, you can kind of look back at the prejudice prong of the ineffective assistance of counsel claim, and so show that regardless of whether a continuance had been granted, it would not have changed the outcome of this case, of this post-conviction petition, because again, this DNA was not the only corroborating evidence. And so when you have this additional corroborating evidence, there was no prejudice. It would not have changed the outcome of the case, and so a continuance would not have changed the outcome of the post-conviction hearing. And that goes for the same reason regarding Dr. Debnam's subpoena. And so the trial court, the post-conviction court emphasized that this was, I believe he used the word fishing. This was a fishing expedition. We had no idea what Dr. Debnam would testify to. And so it was reasonable for the post-conviction court to decide that I'm not going to interrupt this individual's life for a fishing expedition. And again, going back to the prejudice prong, this would not have changed the outcome of the post-conviction petition. And so for those reasons, the court properly exercised its discretion in denying the continuances. And again, the petitioner failed to establish ineffective assistance of counsel. And if there are no further questions, I have one additional point that I didn't emphasize in my brief, but that I noticed in this court's opinion, and that I recently cited, the quorum nobis opinion. One of the petitioner's claims was that counsel should have raised a claim regarding the indictment. He might not have actually been indicted. And I think it's important to note, and this was not in the record, it was briefly discussed by trial counsel, but this court, when it was dealing with the quorum nobis petition, seemingly had a more thorough record before it, and it noted that a superseding indictment had in fact been filed, and that the original indictment was dismissed on May 31st of 2012. And so I think when you're looking at this claim regarding counsel's failure to investigate the indictment, the fact that there was a superseding indictment that very adequately and very clearly indicted the petitioner kind of quashes that claim in its entirety. And I just wanted to emphasize that because I had not pointed out in my brief. So if there are no further questions on any of the claims, state respectfully ask that this court affirm the judgments of the post-conviction court. Thank you.
All right, thank you. Rebuttal?
Just very briefly, Your Honor. Again, I maintain that trial counsel, when he testified that he felt that the DNA was not the key corroborating evidence, I just respectfully disagree with that. I think trial counsel said at one point he felt that the truck being seen on the dash cam was the key corroboration. But, I just maintain that a brief glimpse of the back of a pickup truck, it's not near the type of corroboration as someone's DNA on a ski mask, and that had counsel been able to successfully challenge that, it could have changed the outcome of the case, because all you have are two co-defendants testifying against the client, and, you need some corroboration. And one thing that counsel said, it struck me, if you read his testimony at the post-conviction hearing, he said that at one point, he and petitioner talked about the fact that there was virtually no proof other than the ski mask that tied him physically to the scene. So it seems like there, counsel is acknowledging that he and petitioner talked about, there's nothing else, no other proof that ties him physically to the scene. Yet later in his testimony, trial counsel talks about he didn't think the ski mask was all that important. So there seems to be some internal contradiction there, but nevertheless, I would just respectfully submit that the ski mask was critical in this case. Like I said, on direct appeal, this court, that's the point it really hammered home on the corroboration. And yes, we did not produce the results at the hearing, but again, I've explained kind of how this all went down in the lower court, and I would just ask the court for a chance for this case to be remanded so Mr. Keller can get that service that his family paid for, which is having that mask tested. I think that needs to be done in this case, and would respectfully ask the court to allow that to happen. Thanks a lot.
All right. Thank you. Thank you both for your argument today, and this concludes the argument in this case.
This court is now in recess until 2 p.m.